Good afternoon. Welcome to today's TASA webinar, 3 High Liability Issues with the Management of Special Needs Students. During this program, the presenters will discuss 3 key issues related to safety and security problems involving special needs students in elementary, middle, and high school. Specifically, the presenters will cover lack of accurate understanding of federal law regarding special education, 2, safety concerns, a management issue, and finally, poor management of students, the real problem. The presenters for today's program are Dale Yeager and Andy Demidont. Dale is the president and CEO of Seraph, a consulting and training firm. Seraph offers corporations, schools, colleges, hospitals, government agencies, municipalities, law firms, and individuals a vast array of programs that solve programs. Dale has lectured at many higher education institutions throughout the United States, such as Drexel and Howard universities. Dale is an instructor for the Newman University Criminal Justice Program. Andy is retired from public school education system after more than 35 years of service. During his tenure in public education, Andy served as an assistant principal, high school principal, and superintendent. Andy has been nominated to serve on the statewide task force on restructuring education in Pennsylvania and has been the recipient of numerous state and national service awards. We will take questions throughout today's presentation. If you have questions, please use the chat or Q&A feature located on the right-hand side of the screen to submit your questions. We encourage all attendees to submit questions throughout today's presentation. Tomorrow morning, I will send out an email with a link to the archived recording of this program. We do ask that you take time to fill out the survey that will appear on your screen after today's webinar is over. I now invite you to sit back, relax, and enjoy. I'm going to turn the presentation over to our distinguished guests, Mr. Dale Yeager and Andy Demidont. Dale and Andy, the all yours.
Thank you, Matt. Welcome, everyone. This is Dale Yeager, and you'll be hearing from Andy here in a few moments. Today, we're going to talk about a very important issue. It's certainly an important issue to Andy and I, and also, I know, an important issue to all of you. We're going to be focusing this training webinar to both parties, attorneys and administrators who are part of school systems, as well as attorneys who are plaintiffs' attorneys who have actions pending or possible against school systems. So we're going to be talking to both sides today about this issue. And one of the things that we need to talk about is, first and foremost, the issue of statistics. A lot of times, even educators don't know all the stats related to liability issues and the management of special education students. And here's just a couple of statistics that we would like to start our webinar with. In 2009, the Department of Education, U.S. Department of Education, estimated that over the next 5 years, 60% of all K-12 students would be special needs. We now believe that and the Department of Ed is talking about increasing that number. And so this is a very key issue that has to be addressed from a legal perspective. The fastest growing student. Yes.
Can I just interject at a couple of these slots here real quick?
Absolutely.
The first set of numbers, and first of all, thanks everyone for taking the time out of your busy schedules to sit on this conversation. The first set of data there, I will add a professional prediction. And I've made this statement, and I'm getting closer and closer to where I believe it's going to be. I submit to each and every one of you that over that next 5-year period, we will eventually get to the point where virtually every child is some form of an IEP in his or her educational career. That you're looking at a system that is heading directly towards individualized instruction for every kid. Whether it's an official IEP the way it is written today or not remains to be seen. But some form of that will be where we all wind up, perhaps closer to what typically is referred to a 504 plan for every child. but we're going to get to a point where every child has some level of individualized plan that every public school is going to be required to meet professionally. Thank you, Dale.
No problem. One of the other, the second issue here is that the fastest growing student disability, as most of you know, is autism, which comes in many different levels, many parts of the spectrum. And because of very, very good research that's coming out recently, this does not seem to be slowing down in developed countries, and especially in the United States. Thirdly, juveniles account for 1/3 of all sex offenders. In the past 4 years, female juveniles are the fastest growing group of sex offenders. And so this is important to understand. One of the things that I teach for the U.S. Justice Department is sex crime investigation for federal law enforcement and specialty law enforcement throughout the U.S. and Canada. Canada actually has a higher rate of juvenile crime than we do, even though they're a very small portion of our population. But the thing is that this is something that is eluding many people within education and many people within the legal profession, is this serious issue with female juveniles. One of the things we know about female juvenile sex offenders is that they come from all walks of life, all socioeconomic backgrounds, and they first offend while babysitting. And so this is very serious, a very serious problem. The second biggest group are married white women between the ages of 35 and 50, and then you have various types of males, which have actually kind of plateaued. And so juvenile sex offenders are becoming a critical issue, both males and females. Next, number one issue, whether you are an attorney who represents a school system or you are a plaintiff's attorney, this is a critical issue. Understanding federal law as it relates to special education. And Andy's going to take over here in a moment, but I would just really encourage all of you to really pay attention to this particular part of the webinar, because we find in the numerous, I mean, we have so many school cases that we work on for TASA throughout the year, and it amazes me, and it amazes Andy, how many people in the legal profession do not have a complete understanding of federal law and the different changes in federal law. And this is critically important as you represent your client, whichever side you're coming from. And so Andy is going to be giving you a primer in this particular area. Go ahead, Andy.
Well, essentially, I want to go back to one of the things you mentioned in autism, because it leads right into what we're talking about right now. As Dale had said, autism certainly is one of the fastest growing diagnoses out there for students in school. The problem where we see it occurring most frequently for school districts is in IDA Part C, the early childhood programs, the early intervention programs, the identification processes that school districts are required to adhere to in terms of their partnerships with county government or county governmental agencies to provide services to children at a very, very early age. It's crucial because we're seeing more and more that effective early intervention with kids who are diagnosed with autism and whose diagnosis for autism is clearly delineated and differentiated from all of the different categories that we now have out there. Their success rate in public education is nothing short of incredible. I say that as a professional. I say it as a grandfather of a child who has autism and who, because he or she was identified very early by the school district that he resides in, has made, I can't attest to how remarkable the progress he has made. So the key for school districts is to make sure that they establish the partnerships with local government agencies, local early childhood programs, to make sure that they're out there identifying children who qualify for early intervention programs under IDA Part C. It's absolutely crucial. When it comes to Part B, the childhood services as prescribed in public schools, the major problem we're seeing again is that the services for children with autism do not match their needs. They're oftentimes being given canned or generic programs that do not meet their specific childhood services requirements. And you'll see, at the minute you pick up the IEP, that you're dealing with I don't know how to put it politely, just a canned package that does not identify specific goals, specific supplemental services under IGA requirements that that particular child needs to meet his or her needs.
Andy, are you going to talk about the federal side of things right now?
That is the federal side, the IGA requirements. When you're looking at what the IGA requirements are under Part B and Part C, to provide services. The biggest, a general area with school districts, and Dale touched on some of it, but what you'll see oftentimes, the requirements to keep their policies and procedures updated. I can't tell you how many times we look into an investigative process and we find that school districts have not even updated their policies and procedures, their special ed plans to actually mimic what is required under IDA today. The procedural safety issues.
Let me interject for a moment. Those of you who are listening to the webinar, this is key to hear. The U.S. Department of Education requires that if you're receiving any kind of, or going to receive any kind of grant money for special education, that you must do an assessment of your special education division or department of your school system. So if you're an attorney who has pending action against the school system, this is critical to understand how this plays into discovery. If you're an attorney who is protecting or representing a school system, you need to ask this question. Well, who has done this assessment of the special education department? And it is not allowed under federal regulations to be done by your special ed director. You can't audit your own bookkeeping. So you have to have somebody to assess, are the policies and procedures and the management of these children in keeping with federal law, because all of you know federal law trumps state law. And one last thing, more and more attorneys who are bringing lawsuits against school systems, bringing legal action against school systems, are using the federal courts, not the regional or local courts. They're doing federal civil rights actions. That's critical to understand, because the U.S. Justice Department, when they see a civil rights case in federal court, they will attach themselves to it to monitor it, and it can actually bring an investigation, which there are numerous investigations of school systems throughout the United States by the U.S. Justice Department for civil rights violations of students. And so it's a cascading effect. If you don't ask those critical questions, what are we in keeping with federal law? So, Andy, you wanted to talk about procedural safeguards.
Well, I want to again touch on, because you brought up autism in that first section, and because it presents one of the major difficulties. You have many autistic students who are high-end performers in certain academic areas, and they perform at a very high level at a very early age. And so you, as a school district, you run into the difficulty oftentimes of matching the child's academic ability with your programmatic chronological setup. In other words, if I have a student who is autistic but is extremely proficient in science, I need to make sure that I stick to the guidelines in terms of what the age discrepancies are, the age parameters, the gap between that child's age and the oldest other child in the classroom. We see all too often school districts that will take a high-performing student and put him in a class with students that are 5 and 6 years his senior. And they won't take the time to make sure that they get the proper waivers, parental signatures for the waiver. So it falls into that no good deed goes unpunished. You're trying to meet the child's academic needs, so you put them into a higher performing group, but you don't take the next step to make sure that you sign off and get the parental signatures to get the waivers for the age discrepancy under the IGA regulations. Procedural safeguards, when you deal with procedural safeguards, beyond the very basic fact, and again, in the time we have here today, we're kind of limited to where we can go. But if you look at the basic issues, the basic requirements of making sure that you post that information, that you are able to identify how and what processes you followed to disseminate the procedural safeguards information to parents. All of that type of stuff we still see all too often. School districts are taking shortcuts that get them into trouble. They're not making sure that they update their information on an annual basis. They're not making sure that they post it, they advertise it. Oftentimes, they do that because, like in our state of Pennsylvania, they assume that their local IU or their educational consortium is taking care of it for them, and too many things fall through the cracks under those circumstances.
Now, one of the issues also all of you need to pay attention to, no matter what side you come from a legal perspective, is the issue of local school policies that violate state and federal laws. This goes back to the climate assessment that's required by the U.S. Department of Education. You have to know, are your policies in violation of state or federal law? And this is something that we see constantly, whether we're representing schools or representing students who are taking a legal action against the school system. We see violations of these laws. This is going to cost a school system money and grant money. It's going to cost them legally because it becomes a liability problem, as we call it. It's critically important to understand this. Now, in the state of New Jersey is a great example of this. The state of New Jersey passed a bullying, intimidation, and harassment law last year. We are partnered with the New Jersey School Board Association Insurance Group, so I was actually at the event as a keynote speaker where this was announced by Trenton. And one of the things that I realized very quickly, and I called Andy about this, I said, you need to take a look at this law because I said, I think it violates federal education law. Well, we took a look at it, and Andy, why don't you explain what you saw in that law related to federal law?
I'm not sure what you're referring to, Dale.
Well, that they were applying adult civil rights for civil rights law to children, which violates federal law, which back in the 1980s, the Supreme Court had ruled that children do not enjoy the same civil rights as adults in a school environment. They have to be protected. And we had talked, you and I had talked about this in relationship to federal law. The bottom line is that federal law trumps all things, and even though things have to be worked out in the courts, this can affect cases, whether you're defending them or you're being involved in some type of action against the school system. But one thing I wanted Andy to talk about specifically was the issue of the change in ADA that happened in the fall of last year. Did I get that correct, Andy?
Yes.
ADA had revisions. So why don't you just share briefly about that?
Well, essentially, it just brings again to fruition what I had said to you after your first comment about the percentage of students in special ed. If you look at the new definitions that come out under ADA, you're talking about a scope of services to almost every child with any form of an exceptionality. And the weight of the law carries significant responsibilities for school districts in terms of what their obligations are to a child who is meets the criteria of ADA. And everything from, as I said earlier, having a 504 plan, which has some unique distinctions between it and a typical IEP in terms of what remedies a parent may have if a school district violates a 504 plan. But the bottom line is that schools are going to have to get to the point where they acclimate and service children within the regular classroom, provide those services within the regular classroom, provide the supplemental services within the regular classroom to make sure that that child can be truly identified as an IEP student before they move that way. The process prior to this to get kids identified, I guess the best way to say it is that it was too easy to get kids identified without the proper interventions and measures being taken within the regular ed class setting. Schools have to make sure before a child is placed in special education under an IEP that they have given that child all of the supportive services that they can within the regular classroom setting in order to allow that child to succeed. And if and only then, if the child doesn't succeed, do we take the next step to special ed services, a full-blown IEP.
And Andy and I have discussed this numerous times where attorneys who are representing school systems, the problem here is that many times they are defending that school system blindly because they're being given inaccurate information from key departments within the school system, especially the special ed directors. And what you need to be doing as an attorney who is representing your client, the school system, you need to know all the facts. You need to assess that department and find out everything you need to know about their policy relationship to federal law, so that you don't have any kind of surprises. It isn't
even just how it relates to federal law, Dale. It's in terms of making sure their information is updated. I'll just give you a quick scenario to kind of illustrate what I'm talking about. You have your special ed plan within a school district. School District X, let's just say. School District X has a list of preferred private providers for students who need out-of-school placement. School District X has a student who meets those requirements and needs an out-of-school placement. The child is placed in a school that is not on the district's list. The placement turns out to be problematic for the district, for the child, and for the private school provider. Now we have a school district who has put a child in a setting that is not on its approved private provider list. So you just make yourself unnecessary trouble by not keeping your policies and procedures, and most importantly, your special ed plans in place. We have school districts that have special ed plans. As you all know, that in 2004 we had a major shift. We had the ADA shift last year, and we have districts that we find to this day within their policies and procedures practice that have not updated that material, and it's just an unnecessary problem that why stick your neck out when you don't have to by simply doing good housekeeping in your policies and procedures.
It's very important, in conclusion with this segment, it's very important to know what's going on. Whether you're the plaintiff attorney, you need to have a proper assessment and understand what to ask for in interrogatories, what to ask for in discovery, how to do your depositions, and then those of you who are attorneys with school systems, you need to make sure you have no surprises. That's never a good day. Next is the safety issue. Yes, go ahead, Andy.
I just want to chime in again. One of the things that we see all too often in this highly technical era that we live in, we see school districts that espouse data-driven decision-making, yet when it comes to a student with special needs, they have either limited to no very specific data when it comes to a child's IEP in terms of how they're measuring progress, how they're measuring the goals that are set, how they're measuring their supplemental service. There's just no excuse for that in today's day and age. It should be almost at a touch of a button to be able to access a complete record of a child's experiences within special ed, his or her performances, how they measure not just on the standard tests and measures that are prescribed for them, but how they measure the specific goals, which brings me to one, I said it earlier and I'll say it again, one of the major problems with IEP goals is we're still seeing too many canned goals being entered into a child's IEP, and in some instances, they actually serve to the detriment of the school district because it's so apparent that they have no relevance to this particular child's exceptionality, whatever that may be. Okay, Dale, sorry.
Okay, no problem.
Hey, Andy, we have a question here. Can I pose the question to you? Is this a good time to ask a question?
Yeah, go ahead. It's fine.
Sure. Steve asked, there was a case in Connecticut where a bunch of lawyers petitioned the USDEA/civil rights. Are you aware of this case, and did they audit the district during this case?
I've actually been corresponding back and forth with Steve on this. We are not familiar with the case. Andy, you're not familiar with that case, are you?
No, I'm not.
No, we're going to look it up and have Andy or I get back to Steve with an answer to that question. So we have to look it up first.
Excellent. Continue on with the presentation of content, please.
All right. This next piece is something that bothers me a great deal because, number one, I did my time back in 1980 as a history, world cultures, and civics teacher for juniors and seniors. So unlike Andy, who's had a long, long career, I had a very short career. But one of my great frustrations over the last 20-some years of working with school systems is the assumptions that are made in emergency management. One of the assumptions that people make, and I'm talking about principals and school administrators, is that special education staff are trained in emergency management of special needs students. And now, what do I mean by that? Well, children who have special needs have reactions to fear that are dramatic in many cases compared to children who do not have those special needs. And so you have to be able to have certain verbal controlling tactics to be able to control them and to get them to move as a group in an evacuation, or also to keep them calm. To keep them calm in some type of an emergency situation. One of the things that we found, and we have a pretty good sample because of having actually now over 28,000 schools in suburban, rural, and urban areas, that special ed staff are not trained, and that other staff in the school are not trained specifically in how to handle special needs children within an emergency situation. So if you're an attorney who is representing the school system, this is a critical issue that should be brought up because, again, if it creates a liability bomb, and those of you who are attorneys who have actions pending against the school system, again, you need to understand this one factor because it's a critical factor when a student is injured or hurt during some type of emergency. And don't think of emergencies as just hurricanes or storms or a gas leak. An emergency can be a fight. An emergency can be many things. It can be a medical emergency. And so it's critically important to remember that you can't assume that this training exists because it doesn't. And we've yet to find any school system that specifically has customized training for special needs children in emergency management. Emergency plans are lacking. This is another issue that bothers me greatly. People hand their children over to these adults, professional adults in school systems, and we look at emergency plans that are just, to put it nicely, pathetic. They don't address issues properly. They're not designed correctly. They're unusable. They're not really dealing with most of the issues that schools would deal with. And so again, as an attorney who represents the school system, you need to be looking at these emergency plans. You need to have a formal process for evaluating them and finding out what's lacking in them, because again, that creates a liability bomb. If you're an attorney who has a pending action against the school system, you have to understand how these emergency plans play into your interrogatories, into your discovery document, your discovery list, and your strategy, because this is a critical problem. It's one that we find over and over again. Lastly, and I'm going to have Andy talk about these issues also, is policy updates. It is required under Homeland Security since 9/11 that schools, through the Justice Department, cooperative effort with the U.S. Department of Ed. Most people don't realize that the Justice Department, who I work for, and the U.S. Department of Education have cooperative programs on emergency and safety in schools. And so they're required to update their plans on a yearly basis. Most states that I know of require also a review of the emergency plan on a yearly basis and update. And you would be surprised how many do not. And again, this is a critical issue. Andy, would you like to talk about some of this also?
Well, the emergency plan is, again, I keep coming back to this. People are going out and buying canned packages, and it takes 5 minutes to look at a school district's emergency plan and tell very easily whether it is appropriate to their setting. The first obvious question is, how do you do an emergency plan without having a full-blown assessment first? You can't. It's impossible. And so what happens is, to circumvent many times the requirements for getting an emergency plan in place, school districts are relying on canned packages to do it for them. And as I said, it just does not work. You'll see it right away there in terms of their evacuation procedures. You'll see it right away in their recovery procedures. You'll see it in how they have their relationships set up with first responders, local first responders. You'll see how they have it set up in terms of their disaster centers, what controls there are, who's allowed to come and go. It just shows up very quickly as to where the whether it's a disaster plan or an emergency plan that has been thought out at a local level. I'm not opposed to starting with a framework, an emergency plan framework from somewhere, but you can tell whether the planning at the local level has actually been done with local folks, and that the modifications that match the local geographic and socioeconomic and cultural needs have been built into the plan. As far as training is concerned, let's think about it very simply. Most people who are in the education profession for any length of time, in their college training, have had little or no emergency management training for special needs students. So they have had to rely largely on whatever districts they were associated with. And frankly, some districts have done an outstanding job with keeping their staffs up to date. Other districts have not. There's an economic reality here that districts have to face as well, that the districts who are sort of behind the 8 ball are usually districts that have serious monetary issues and just don't have the financial wherewithal to provide all of the necessary kinds of trainings that NIMS requires and a real accurate emergency plan would require. And what you'll... Go ahead. I'm sorry.
No, I wanted to say something about that. One of the things that I get very angry about is when I hear, and we work in 20 states, I hear school administrators and I hear school board members say, we have no money. I will tell you that right now there are over 9 different grants available through the federal government to any type school system, rich, poor, or in the middle. And what I hear constantly from business administrators and from superintendents is that they are too tired They do not have the time to apply for these grants. Most of these grants are related somehow to emergency management or special education. So when a school doesn't have, as Andy talked about, they don't have the proper funds, the money is available, it's just in many cases they're not being professionals and applying for it because they don't want the aggravation. But ultimately the money is available. There's one grant in particular that has over $40 million available for special education, and part of it can be used for emergency management and security. So the thing is that money is available, and this factors in if you are an attorney who represents the school system, because any good plaintiff's attorney is going to find that out and ask the question, well, why didn't you apply for grant money? Why didn't you apply for these funds so that you could bring everything up to speed? But go ahead, Andy.
Let me add another piece to that that's even more damning for local school districts if you represent them. And that very simply is their failure to develop working relationships with their own local EMTs, fire departments, police departments, because those resources oftentimes can help them get their staffs the training at little or no cost to the local school district. So, I noticed there's a question posted here, and I'm going to answer it from Sydney Webster, and it says, the question basically is, does the emergency plan include keeping the general population safe from special needs students who may be violent? And the answer is yes, it should. There should be procedures in place to keep all the students safe.
Yeah, there's no, in answer to that question too, I would say there's no excuse for any of this happening. One of the things that aggravates me is, as a person who's a forensic psychology expert, I hear people, and I hear professionals say this statement, and they mean it. They say, well, you can't stop everything, Dale. And I will tell you after a 22-year career that is absolute nonsense. You can stop almost everything with proper formal planning, formal process, and good management. And what Andy and I find on a regular basis with our team, and our team is all retired, highly experienced school administrators, and we find constantly that the issues in schools that create the liability are management issues, lack of proper management. And so, one of the things that we talked about earlier was sex assault. Well, the U.S. Justice Department several years ago recognized that most sexual assault in schools is by special ed students, and the victims are special ed students. That's where the predominant amount of it is going on. So this has to factor in. If you're an attorney who represents the school system, you need to know that. And if you're a plaintiff's attorney, you need to know those facts too. It's a very big deal. But I get aggravated when people say you can't prevent everything. That's because they don't understand how to do it properly. And it is available. You can prevent most things with proper management and a formal plan of action. So,
well, the question becomes, did you as a district do what is reasonable and prudent? Back to what I said as far as the training is concerned. The question that I would ask a school district when they tell me is that they can't afford and don't have the financial wherewithal to provide staff training, I'll ask them a very simple question. What's your working relationship like with EMT, fire department, and police department that services your community? Children and youth, probation department. What is your working relationship like? Do you have a meaningful partnership? What do you mean by that? Very simple. A meaningful partnership should be where you and they meet at the very least quarterly during the course of a year to discuss strategies to effectively work with providing staff tabletop exercises to prepare them for emergency management situations, to provide them with instruction like in Jersey that Dale was talking about with HIV harassment, intimidation and bullying awareness. The local police departments and fire departments and district attorney's offices and children and youth have resources available to provide districts that kind of training. So if I'm a reasonable and prudent educational leader today, I'm going to capitalize on that. if I'm involved in litigation, it's going to come back and bite me if I didn't. I need to make sure I take those steps to prevent these kinds of issues.
Another issue, folks, is this, that most states have a portal-to-portal law, which is very misunderstood. Portal-to-portal means very simply that you, as a school system, are required to protect that child. You're responsible for them from their door back to their door. Well, you have school districts all over the United States who allow seniors to go out for lunch unattended. That's a violation of state law. And when we talk to school systems about this in various states, the attitude is, well, the parents want it because they had it when they were in school. It doesn't matter what the parents want. It matters what the law says. And when you're going to violate the law, you as an attorney who's representing the school system, again, another liability bomb. And if you're a plaintiff's attorney, that's something that you have to jump on because that's where they're violating the law because they're allowing these kids to go out. What happens when there's an emergency? These kids are on their own. If there's a crime committed, if they become a victim of something. And in emergency plans, that has to factor in. What is the law? What is the law locally? What is it statewide? What is it federally for proper emergency management? And this is something that doesn't get addressed, and it should be addressed. This is very, very important. Also, various states have rules about meeting quarterly, like Andy talked about. Some talk about meeting monthly. If you're an attorney who has an action pending against a school system, you need to look for those records. You need to know what records to look for about the meeting and look at the meeting notes. And if you're an attorney that represents a school system, you have to ask, well, do you keep notes of these meetings? Do you cover what, within the bounds of law and discovery of student information, do you talk about the basics of what's going on within the school system? This is critically important. This is so important. And it's not being done on a general basis. Now, let me say something about New Jersey. Back in August of last year, the Department of Education in New Jersey put out a new security safety mandates law. And they sent it to every superintendent in New Jersey. And we do a lot of work in New Jersey. So we waited. And we advised all of the organizations in New Jersey, educational organizations that we are partnered with, that this law existed. And not one, we have surveyed, not one superintendent passed that information on to their business administrators or to their safety teams. Those mandates have to be breached by October 15th of this year. We are now going across the state for the School Board Association Insurance Group advising these administrators on how to meet those mandates. There are 91 different mandates that you have to comply with specifically, 340 different pieces total. That's a lot of work, and they're very detailed. Most school systems, in my opinion, are not going to reach that goal, and they're going to pay for it financially, but it also creates a liability bomb because they're not taking it seriously. We've told them, if your safety team does not start working on these mandates by July 1st, you will not reach that goal. And many of them are just not treating it with any seriousness. So as an attorney who represents a school system, you need to be holding them accountable for things that create liability. Secondly, if you're an attorney who's a plaintiff's attorney who has an action, you need to know about those laws and how they relate to the management and daily actions of administrators within a school system. So, anything else you want to add, Andy?
I just have a question for Steve, and it regards the Connecticut case. Is he referring to what's become known as the PJ case in Connecticut?
I'll seek clarification from Steve on that, Andy.
Because if he is, it's an interesting for everybody who has work in Connecticut, because what you're dealing with essentially in that case is it has essentially forced school districts to get rid of the old self-contained, to a large extent, get rid of the old self-contained special ed classroom environment. And it's put a tremendous amount of pressure on school districts to provide alternative placement services, private special education programs. It parallels to a large extent what happened here in Pennsylvania when the Gaskins consent decree was pushed through. I'm just curious if that's what he was referring to.
And Andy, I've sent a message to Steve seeking clarification. Dale and Andy, we do have a question here from Daniel who wants to discuss the issue of playground safety and precautions for special needs students, especially supervision and fall prevention. Are there any specific guidelines or statutes that have been issued on this topic?
Andy?
Basically, the best advice that I can give anybody with a special needs student in any extracurricular, there's a whole segment of extracurricular guidelines and co-curricular guidelines that are required, but the best advice I can give to a school district is very simply this. If it's important enough to do, make sure it's in the IEP, and if it's in the IEP, make sure everybody knows that it's in the IEP, and make sure that it's monitored, make sure that you're living up to what you said you were going to go do in the IEP, and most importantly, make sure that you can document it. You know, if a child requires supplemental services because of safety issues on the playground, obviously you're going to want that in the IEP. Obviously you're going to want to make sure that that's being executed the way you have it stated, and make sure that you can measure it.
Andy, Steve was referencing the quote-unquote PJ case.
Okay.
Okay. Well, let's move on to the poor management of students. Again, I alluded to this before. Andy has talked about the IEP issue. Andy, would you like to talk about behavioral manifestation termination for a moment?
Well, two of the biggest myths surrounding special education center on discipline, okay? The first perception is that if I'm a special ed kid, I can't be disciplined. Absolutely not true. I can be disciplined in the same manner that a regular ed student, unless a behavioral manifestation is determined that my behavior is directly correlated to my exceptionality. Short of that, I can, to a large extent, discipline a special needs student in the same manner that I do a regular ed student. The requirement for behavioral manifestation determination hearing is you have a student who's had a series of problems. Do you bring the IEP team together, including the parent, and determine whether this particular behavior relates to the exceptionality? If the answer is yes, it is a relationship to his or her exceptionality. You obviously have essentially stay put provisions within the program until the team decides that the program is not meeting the child's needs, and that needs to be changed. If the behavior is determined not to be related to the child's specific exceptionality, then I can follow my discipline guidelines as I would for a regular ed student. The caveats deal with the time parameters that I deal with out of school or in school suspension, or the new measure that we're seeing quite a bit of is that schools aren't suspending kids out of school with special needs, but they're keeping them in the office, ostensibly under the premise that they're waiting for parents to arrive, and the clock's running. If you're keeping that kid in the office, in the principal's office or the guidance office or a resource room when that's not part of the child's IEP, you know, if it occurs habitually, you run the risk of violating that child's adequate educational program and services.
Okay. Next is the information disconnect. Andy, would you like to say a few things about the information disconnect?
Well, the information disconnect essentially it deals with what we've talked about several times already. The fact that when revisions are coming up, again, the ADA regulations that came out in 2010, I still see all too often too many districts who have not complied with the requirements that is placed on them. Worse yet, aren't even aware of what those requirements are.
Okay. Next is four assessments, physical disability versus personality disorder. It is amazing to me as I train psychologists, psychiatrists, and social workers, and I have for many years, that many of them really do not understand, not all, but many of them do not understand the difference between a physical disability and a personality disorder. Personality disorder would be something related to aggressive behavior, behavior that is antisocial. There are many, many words for it. In forensics, we say that they have psychopathic or sociopathic behaviors because you can't actually say they are full sociopaths or psychopaths until they've reached somewhere in the 16 or 17 years old. But one of the things that the Department of Education has been toying with for several years, and I believe, in my opinion, that they're going to do this, is that they've talked about the idea of separating out children with personality disorders from special education and putting them back into the regular classroom, and they'll give a school district a certain amount of time to make that transition. I think that's going to come at some point, just for many reasons, but one of them being economical. It's critically important that your special ed staff is properly trained. Don't assume that they are, and understand, and even the general staff of a school system be properly trained to understand these psychological issues, because I find that some special ed instructors do not know the different manifestations of autism, for example. If you're a special education teacher, this is something that you should know. And so there are gaps in information disconnect in the training of school staff and administrators in this area. And so this is an issue, if you are an attorney representing a school system, that you need to know about and address. If you're a plaintiff's attorney, this is something you need to look into. Is the quality of the training, what they're trained in, are they tested after their training? This is a critical issue in devising a case. Secondly is parents and disability assessments, not my child. We find many administrators contacting us as clients saying they're very frustrated because they have parents who just fight constantly to have their children assessed psychologically for disability. This is a very big problem, and it can be political, it can be ethnic, it can be cultural. It has many different reasons, but this is a serious, serious issue. Andy, would you like to talk about any of this poor assessment issue?
No, I think you've covered what we need.
Okay. And lastly, I would say this, just as we finish this segment, is that many psychologists are not trained to properly assess and make determinations of a child's disability. You know, and part of the problem is that we see that some of these children, many of these children, are improperly diagnosed. And so this is another issue that can create liability issues down the road. So what I'd like to do now is turn it over to Matt, and we'll take any more questions that you have. We'd like to answer all of your questions.
Okay, excellent. Well, thank you to Dale and Andy for a great presentation. And for everyone in attendance, if you have a question for either Dale or Andy, please use the chat feature or the Q&A feature found on the right-hand side of the screen, and we'll get your questions answered in the order in which they come. Dale and Andy, we do have a couple questions that are already in the queue, so we'll just get started. What legal role does the principal have over the special education staff and how they perform their duties?
He, in simple terms, he's in charge. At that building level, he is in charge. They work at his building or her building. She is responsible for, or he or she are responsible for them. You know, the distinction, a special ed supervisor, I don't care how large the school system is, the building principal I don't care how far you go into any kind of case law, and I don't care what the topic is, whether we're talking about special ed, whether we're talking about overall building security, whether we're talking about instructional programming, the building principal is the person who is in charge and responsible and can be held responsible unless he or she can demonstrate that they were given instructions from their superiors that contradicted what they knew to be the correct course of action. You're in charge. You can't wash your hands at the building principal and say it's the special ed supervisor or it's district office. It doesn't work that way.
And I would say too that Andy finds this, and I've seen it myself, that many principals, administrators, when you talk to them about the state law in the specific state they live in as to what powers they have, many of them do not even know state law as it relates to their abilities or what they're required to do, which is pretty frightening unto itself. One of the issues that we come up with a lot in the security management audits that we do is the issue of knowing what a principal is allowed to know about the students. So if you have students that are on probation, in most cases a principal is allowed to know what students are on probation and what they're on probation for. Well, this is critically important because if they're on probation for sex assault or sexual harassment, they're going to need special care to keep them, to protect other students. Many judges will not isolate children and adolescents who are sexually predatory, and so they'll put them back into the school. It's extremely common, and it's important that administrators be trained to understand what the law is in relationship to what their powers are and what they can and cannot do. Many of them don't know the full scope of that. That's what we have found.
But the real problem goes back to what I've said now. This will be the third time, and that is essentially what are the working relationships between the school principal and the local EMTs, the local fire department, the local police department, children and youth services, probation. Are there systematic ways where they share discussions? I'm not talking about the building now has a problem with the student and then the principal decides to pick up the phone and call probation or children and youth and ask for their help. I'm talking about systemic working relationship where, as I said earlier, at the very least quarterly, and my preference would be, as Dale had said, monthly, the school has a meeting with representatives from each of those entities, and they discuss as much as possible their mutual and shared interests in the children that they are all designed to serve and protect. They can go a long way to preventing problems from occurring. The sexual cases that Dale is alluding to, all too often, many of those problems could have been prevented had there been that kind of rapport between the school and the agencies that I'm referring to. And in this day and age, if you're serious about safety and security, not just of special needs students, but all of your students, it is, in my opinion, negligent not to have that kind of working relationship.
And I would say too that I think that I know that if most parents in the United States understood the amount of sexual assault that goes on in schools, and suburban schools, by the way, they would be shocked. I think that it would prompt a nationwide protest by parents to fire people, because we have numerous situations where police have had information because they're doing drug stings or drug operations that involve a school, where they find teachers having sex with students, and very common, and the school district, in an effort to avoid lawsuits, will just ship those people to another school, put them in another department. No one's getting prosecuted. There's a lot of dirty little secrets going on, and then we have superintendents where the Justice Department has come in and investigated superintendents and principals who have paid off families where there's been sex assault between two students, instead of reporting it to the police, have paid off families to keep them quiet. And the Justice Department has been involved in numerous situations like that. There's a lot of things going on in there, so if you're an attorney who represents the school system, you don't want to have any surprises when you're trying to represent that system. And if you're a plaintiff's attorney, how deep are you digging? Do you have all of the information you need to represent your client? I mean, it all comes down to that issue specifically. Matt, there's a question from Steve about court-appointed special advocates.
Okay, go for it.
Andy, would you like to talk about that a little bit?
I'm not sure what the nature of the question is.
Well, Steve, are you talking about court-appointed advocates from the state who are overseeing the school system? We're trying to clarify your question.
I'll seek clarification from Steve on that. Going back to a question that was posed earlier, Daniel had posed earlier a question about playground safety and the precautions for special needs students, especially with regard to supervision and fall protection. He was wondering, because I think that he's looking for a little more, and he believes that the answer was cut short a little bit, is there any more on that issue that schools can do besides adhere to an IEP?
Andy, can I
to mitigate risk? Yep.
Yeah, Matt, let me answer that, if you would. Playgrounds are part of your emergency action plan. And one of the things we find is that usually the management of playgrounds is a very poorly written, poorly designed, or just completely ignored issue with an emergency plan. You have several children last year in the United States who got struck by lightning. There's no excuse for that. That's really part of a process that should be part of the emergency plan. And when you have special needs children who have violence issues or sexual aggression issues, the management of those children when they're at play with other students is critically important. It's all part of that process of asking the question, well, where's the formal process for assessing the special education department? Number one, whether it's in violation of federal or state law, and number two is, how effective is their management of these students? And until you do that, you can't even start to address those specific issues to protect other children, if I understand the question.
Well, and on top of that, you obviously have all of the equipment, safety and security requirements for the equipment that you place on a playground. So I was assuming that was not part of the question, but just in case it is, you have a whole set of guidelines for safety and security of playground equipment, everything from the type of swing sets you use to the kinds of slides you use, what the fasteners are to be used. So there's a whole set of guidelines that are what are considered best of practice when it comes to that. Also, when it deals with special needs students, one of the issues that you see oftentimes, and this is why I brought up the IEP, that school districts, because of perception that they may not, or reality that they don't have the staff, will use contracted service providers or aides to supervise playgrounds. If I had $1 for every time that we ran into a situation where an aide like that on the playground was not made aware of what a special needs child's service plan required, or attention and safety issues that were required for that child, I would not need to worry about the Powerball lottery this Wednesday.
It's a serious management issue, Matt. It's a serious management issue, and there's no excuse for it. And it's one of the great deficits in school management that we've seen. One of the things we've recommended in the past is managed play, and that's where you set up activities that children can choose from, where you're actually managing the way they play. Well, there's good and bad to that. Some people are offended that kids can't just go and play on their own, but with managed play, you can control behavior a little bit better, but it all starts with an assessment. You have to assess. I and that's the bottom line. So.
Okay, great. And we'll pose our final question from Heather, who asks, could you share your experiences with abuse at the hands of a special education teacher? What type of physical contact is acceptable between a special ed teacher and a child with autism?
Andy?
Okay. The question for that particular student, it's very generic, very broad, and so it's difficult to answer. And there are a lot of aspects to it. Number one, what kind of training did the teacher have? Let's begin with that. Were they provided the necessary training for acceptable restraints for students who have maybe not even necessarily violent tendencies, but who are subject to severe spasms that potentially present a risk to them or to the students around them. What kind of training were the teachers provided? What kind of training were the aides provided? The best answer I can give you again is, what does the IEP call for? What have you met with the parent and the IEP team have agreed are the acceptable types of restraints? And furthermore, what does your state allow? Because it differs from state to state. Some states have almost total hands-off regulations, and other states are not quite as explicit and would be more inclined to look at the training of the professional, what the restraint was, what the circumstances around the incident were, and then determine whether it was acceptable or not. Okay, it just depends on where you are and what state you're situated in, and you need to be cognizant of what that requires. Also, what your local board policies require. Okay, if your board policy says is a total hands-off, you have a problem if you're a teacher trying to restrain a student and something happens, unfortunately, to the student. So.
Yeah, one of the other issues that we see a lot of in relationship to that question is that you have a lot of stressed out special education teachers who are overworked and they aren't properly trained, but more importantly, they're not properly managed. And so you have special ed directors who are not managing their staff very well. They're allowing them to get stressed out, and they end up getting emotional and getting tired, and in some cases striking students or shoving students. There's no excuse for that, but at the same time, that's a management issue. And again, that comes back again. I know I sound like a broken record. Assessment, assessment, assessment. Monitoring and assessing the special ed department to make sure it's working effectively. And so I would just say that comes down to it, and that's the key to the universe in that case. So anyway, Matt.
Dale and Andy, we had a last-minute question come in from Brian Case who asked, what is a court-appointed special advocate?
I don't know. Well, in some states, that's an advocate that in some cases they're looking to see about the treatment of a specific child. I know that the federal Justice Department does that when they believe a student has been not mistreated. There's also special state advocates that are appointed by courts to oversee the management of school systems. I'm not sure what that term relates to.
A special advocate can represent a specific child, depending on a court order. A special advocate can represent, in some cases, in some states, the governor and the legislature having essentially taking over a school district that they perceive to be deficient in various areas. So you have several different, depending on what the state you're talking about is, and what the situation is. That term has several different connotations depending on where you are.
Okay.
Yeah.
And we have a final question.
But again, any kind of, Matt, let me say this. In relationship to that question, contact Matt, and he can arrange for us to talk to you, either Andy or myself, to get an answer to your question. So Steve has some questions, and I've asked him to contact you, Matt. That's the process that we use. And then we'll set up a time to talk to you and get your questions answered. So.
Okay, excellent. And just the final question here, and then we'll wrap things up. Very briefly, can you guys talk about the pros and cons and, I guess, the utilization of screen rooms with respect to special ed or special needs students?
Andy?
Yeah. My professional opinion is they have a temporary, momentary place under certain circumstances, but the unfortunate aspect of it is that they have been abused over time. They've become the self-contained environments that some kids live in forever. There are a place where let's say an autistic student who needs a period of time to calm down, where they're put in a environment where they don't feel threatened. The problem with what my experience with screen rooms is that they have been part overused. Let's just leave it at that, okay? If used correctly, it can be helpful. The unfortunate part is that there's an opportunity for abuse there.
Okay, thank you. And to Dale and Andy, thank you again for the time and effort that you put into this presentation. And to all the attendees, thank you for taking time out of your very busy schedule to spend an hour with us talking about this issue. If you'd like to speak to Dale or Andy about a case or project that you're currently working on, you can contact us here at TASA. Our telephone number is 800-523-2319. I'll be sending out a link to the archived recording of this webinar tomorrow morning. In that email, I will include a copy of the PowerPoint presentation that was used during today's program. The archived recording of this program, as well as all of our previous webinars, can be found in the TASA Knowledge Center. Visit our website, tasanet.com, and click on the Knowledge Center tab at the top of the page. You'll be taken to the list of previous webinars. Our next webinar for legal professionals, Refinancing Tax Problems for TIC Owners with CMBS Financing, will take place on June 19th, 2012. Please look for an invitation from me in the coming days. If you have any follow-up questions or comments, please email me at mhi@tasanet.com. We do take all of your comments under consideration, and they do help us to produce better programs, so please feel free to send me an email. With that, I will end today's program, and thank you to everybody for your time and your participation.
Thank you, Matt. Thank you, everyone. Bye-bye.